Hello and a warm welcome to the special program on the Federal Capital Beat. The Center has amended the Prevention of Money Laundering Rules 2005 and has brought in a new definition of a category called politically exposed persons, which is called the PEP. And this category will include a number of people like senior bureaucrats, military officers, judicial officers, which probably will include judges as well. And the ambit of the ED, of course, has been widened, which it means that ED will have access to the financial history of all such persons who will be included in the category of politically exposed persons. Apart from this, the center has also brought in rules to tighten the cryptocurrency exchanges, e-wallets, and of course, the mobile gaming apps. But talking about the expansion of the financial scrutiny, it's important to talk about as to why these amendments have been brought in just a year before the next general elections are due. The timing, of course, is questionable because it comes at a time when already so many raids are happening across the country. So what will the government really achieve through these amendments? And are these amendments constitutional? Did the government really need this definition of a PEP? I'm going to talk about all this, and joining me is Manu Sharma, who is a senior lawyer in the Supreme Court, and his forte is tackling the cases related to PMLA. Thank you so much, Manu, for joining on the Federal. And my first question to you is, how do you really see these amendments which have been brought about in the PMLA Act?
Well, I mean, as far as this new definition, carving a new classification of people is concerned, which is termed as politically exposed person, according to me, I mean, it's not really required. It's a case of legislative redundancy. I mean, who isn't politically exposed in the country? I mean, anyone can be. Every citizen who walks the street, everyone who's living and breathing and who has some bit of interest in the country's running is politically exposed. You will have a particular leaning one way or the left, right, center. So politically exposed can be anyone. Why bracket it or classify it or restrict it to, say, armed forces officer or judicial officers or people who are running political parties? So that bit I found a bit strange. Now, I don't know what the underlying or background intent is. But PMLA, as it stood before bringing in this definition of politically exposed person, as it is, it covers everyone. And I mean, and it can apply to any person who ends up dealing with proceed of crime, something that has arisen out of...
Sorry to interrupt you, but the fact that the judges and the military officers now will also be included. Earlier, were these categories covered by the ED ambit?
Niruji, PMLA or any penal statute for that matter applies to everyone. Everyone who ends up on the wrong side of the breach of a penal statute is covered. You don't have to say it in so many words that A, B, and C, and D are now in the ambit. They were also in the ambit a little, I mean, before bringing in this definition. How were they not included before this? And how were their records not being kept by a bank and other people's bank records were being kept or maintained? Essentially, this definition is only brought in for under the maintenance of rules, PMLA. So previously also there, I mean, any person who holds a bank account, his records are stored for years and years. I mean, now there are apps. You and I can download our 10-year old bank statement. I'm sure the agency can do that as well. So why now say it so expressly is what baffles me. That's what I'm trying to say. And why only put it to four categories?
Yeah. Manu, I was also reading it somewhere that these amendments have been brought in just ahead of the Financial Action Task Force meeting, which perhaps will happen sometimes later in this year. Now, Financial Action Task Force obviously monitors the money laundering and, how the governments have implemented the rules. So are these amendments brought in with an eye on this Financial Action Task Force meeting? Has it got to do anything with that?
I mean, as I said, I mean, it baffles me. I really don't know the background, but it has nothing to do with the Financial Action Task Force meeting or how our government is going to present its case in terms of how PMLA has led to more prosecution or success insofar as tapping or arresting the issue of laundering is concerned globally. So I don't see how it is relevant. But yes, I mean, if they can come out with the reason, or if you get to know, please inform me as well. But I don't see any link between the two.
But Manu, I'm very curious to know, you said that this definition was not required. It was already there. PMLA cases were happening. ED did have all the powers. And of course, this new category, which is now bracketed as PEP. Now, what is it really going to do? And I mean, like, how does a common man understand? Does it really expand the financial scrutiny? Does it tighten the leash further on these people who are going to be included in the politically exposed persons category? How does one really see it?
First of all, they need, I mean, as I said, it was not needed in the first place. Why, I mean, why bracket, why put 4 or 5 kind of persons or individuals as politically exposed and leave out 95 others? There may be, I mean, if there are 100 kinds of individuals under possible future scrutiny, or their actions or their bribe taking propensities or their laundering propensities, how are the others not? I mean, that's what I'm trying to say. PMLA covered them in the past, PMLA covers them in future, PMLA covers it a day before the passing of this definition. So, but yeah, I mean, in terms of perception, as you said, how is the common man going to view it? I mean, common man is the best person to answer it. But yes, as a common man, I'm also a common man. Yes, I see this as something which creates an unnecessary element of feeling pressure or stress while discharging official functions, be it armed forces, be it a judicial officer. Now, that's the bit which I, as a common man, have a problem with. Why subject anyone to any special kind of treatment when that category of individual is any which way already covered under the law which you're trying to apply to him in case he's found to be in breach thereof? So terming them and making them included in this definition is something which I really can't make head or tail out of. So that's how, as a common person, I see it, blowing a little bit of law.
Manu, from what you just said, am I to understand that this looks seemingly like some kind of an intimidatory tactics or some kind of a psychological pressure, which probably the government will try and inflict on all these PEPs, the new category of people?
I mean, no, I can't give you this answer. I mean, I think a politician is the best person to deal with it. As a lawyer, I can respond to it. It doesn't send the right signal. It does not look appropriate in our polity, in our constitutional scheme. This definition is not required in the first place. That's how, as a lawyer, I can respond to what is, whether it is intimidation tactic or not, I really can't understand. But yes, it is not. As a lawyer, I can say it breaches constitutional norms. It breaches all kinds of appropriate kind of governance that should be there. I mean, why put someone in this category when the law anyway applies to you?
But earlier also amendments have happened, and they have taken place to the PMLA Act. Now, yeah, those amendments and this particular amendment where so much of tweaking has done to the extent that some new category has been brought in, and the government is talking about the expansion of the financial scrutiny. How does this amendment really differ from the earlier ones?
So PMLA was brought into force way back in 2005, and it has undergone amendments, and the few major ones I can take you through with is 2008, when many scheduled offenses were made part of schedule of the PMLA. So the real expansion of PMLA took place in 2008, when 2005 PMLA had only 4 offenses which were covered, whose laundering could be covered under PMLA. Suddenly it became 22, 23, 24, and then 36. 2008 was the real expansion that happened. 2013 also some amendments took place wherein strict bail conditions were brought in. 2018 was an amendment which I personally have had a huge problem with, because a Supreme Court's express judgment was sought to be overcome to bring in the stringent bail conditions again. That makes bail difficult for people who are facing PMLA prosecution. And the element of projection, which was first to begin with an important aspect of the definition of money laundering, was made a
Sorry to
dispensable.
interrupt you, Manu. You are referring to the order where unbridled powers were given to the ED, that they can attach the property, they can arrest, they can seize property. Are you talking about that? Are you
I'm
referring
not
to that?
talking about that. 2018 was an amendment, whereas 2017 Supreme, yes, 2017 Supreme Court judgment saying that twin conditions which a person must satisfy in order to get bail, which is a huge departure from our bail jurisprudence, has no place, and they were struck down. To overcome that Supreme Court judgment by Justice Nariman, 2018 brought in an amendment that bringing Section 45, the twin condition, back into the PMLA Act. That was the first one. The second one was, it was made more stringent. Previously, projection of tainted as untainted was an essential ingredient. You know, money laundering is about washing your dirty money, bribe money put into a bank account and treating as a fees or a commission, which has a legal character, or as a restaurant receipt or a cinema hall receipt, something which has ill-gotten, washed into a mainstream banking channel. That's what laundering is. So projection was an important element. Projection happens when you introduce dirty money into a banking channel and treat it in a certain way in your books. That was done away with in 2018. That was made one of the ingredients, but not the most important one. Previously, it was the most important one. So it made, in a sense, what you're saying, the powers became more unchecked. So the result was that anyone remotely associated with a person who may be guilty of laundering, anyone remotely coming into contact with that person, his driver, his cook, his maid, his accountant, who may not even know what their employer is doing, may get into its scheme and a possible breach. So the 2018 amendment made the entire object of PMLA, and as you mentioned, Financial Action Task Force, a complete redundancy, and it made it very oppressive in the sense, because if you remove the projection element as a non-necessary one and mere handling someone's cash as money laundering, you know how much abuse it can be subjected to. And I'll give you an example. Say one person robs a bank and he lands at the doorstep of his friend at the dead of the night. He says, just keep this bag overnight, I'll come and collect it. Don't open it. That person just keeps it overnight. In the morning, his friend comes and collects a sack full of cash. In the previous definition, that person who kept it overnight without knowing the contents would not be covered, because there is no laundering. There is only handling it without even knowing the content thereof. But in the new definition, in future, if that person deposits it in a banking channel, because his friend kept it overnight, can still be guilty of PMLA, whereas he had nothing to do with the projection element. So that's how oppressive it became in 2018. That was a major.
If you're saying that 2018 and also the previous ones, each time the amendment was made more stringent, was made more oppressive. So talking about this particular category of PEP, which has been introduced, so do we call it arbitrary? Do we call it, in the legal parlance, so do we say it is unconstitutional? Is it oppressive in your language, what you said?
I would say it's redundant. It is unnecessary. It is unnecessary. Your act applies to everyone, even if you don't bring in the political.
You say redundant. Sorry to interrupt you, Manu, but the moment you say redundant, immediately raises the question as to why the government did it. And in the legal landscape only, I would again, of course, you would not answer the political question, but in legal terms, does it not really raise some kind of a doubt as far as the intentions of the government are concerned?
Well, that's a question again. I mean, I would not get into a speculative realm and say government has some ill intention. Maybe they were badly advised to bring in this definition. Who knows? I don't know the trigger of it was. As a lawyer, I can tell you, it is not required. That I can tell you.
So it's not required, you're saying. So coming back to this PEP category, I was reading that, there are a lot of things which have been left to the interpretation as to how does one interpret, and there are absence of some clear markers as far as the new amendments are concerned. Now, say for example, up to how much time would a person be considered as a PEP, even supposing if he demits office? So how long would you consider him to continue as a PEP? So all these things, and up to what rank, supposing if it's a bureaucrat or a military officer, so up to what rank do you consider him as a PEP? How is the new, the new amendments, how will they address these issues?
That's, as I said, it is unnecessary. And if you look at the bare definition of it, according to me, in our constitutional scheme, the armed forces and the judicial officers sit on a higher footing. And in my personal view of whatever I know of our constitutional scheme, they are the least politically exposed person. They discharged their function strictly in accordance with the as far as army officers are concerned, their protocol. And as far as judicial officers are concerned, they just read the constitution and every law that has come out of that constitution which governs us. How are these people politically exposed? I really don't know.
You're saying to bracket the judges or the military officers under the category of politically exposed persons is really not right.
It's not right, according to me. I'm sorry I'm being repetitive, but I don't see how they are any more politically exposed than you and I, or my cook, or your cook, or anyone having a political line of thought who casts his or her vote, who may have a particular ideology, left, center, right, whatever it is, how our politics run. But I don't see how judges are politically exposed. It baffles me, as I said.
A lot of it has been left to the discretion of the ED officer now. Whom does he consider as a PEP? How does he really tackle with him? So, and anyways, there has been a lot of criticism in the manner, about the manner in which ED has handled cases. And now that we know that ED has the power to attach the property, seize, search, and Justice Khanwilkar had given that order. And after that, Justice N.V. Ramana had come down heavily saying that, it's like an arbitrary application. We all know that. And now coming as it does, after all what has happened in Supreme Court, and now you have this amendment, legally speaking, what does it really behove as far as the democratic structure or the constitution of our country is concerned?
The judgment passed by Justice Khanwilkar is under review before the Supreme Court.
Right.
And I think very soon a larger bench will consider whether the findings of that judgment hold water or they need to be revisited. I'm quite hopeful that some of the elements of that judgment, if not all, will be revisited by the Honorable Supreme Court, and we'll have a clearer and a more liberal interpretation of PMLA. What it behoves? Well, as I said, 2008 was the major amendment, and 2013 and 18 have also seen major amendments to the PMLA. Yes, this act is oppressive. And as a lawyer, I can tell you that so far in my assessment of how Enforcement Directorate has proceeded, this discretion of attachment, search, seizure, arrest has not been exercised with the kind of discretion that we expect from a government officer. Many times, and I'm not singling out politicians, many businessmen are also facing PMLA prosecutions all over the country. And in a large portion of those cases, if you get down to analyzing the merits of those cases, you will see that it's been wrongly applied. And there are many legal issues arising out of multiple prosecutions, double jeopardy, a person facing multiple agencies, actions for one single act. So many issues, which I hope, in one of these cases, it will be raised and the courts will come down heavy against the Enforcement Directorate, their understanding of what PMLA is. But in my experience, it's been applied largely, if not all, I won't say all, but in a large proportion of cases that I ended up handling as a lawyer, I found them not having applied PMLA properly. And it's 2018 amendment of expanding and doing away with the element of projection as not being a necessary ingredient has only made things worse. And laws, criminal laws, need to come clean on the standards of Article 21. They cannot be oppressive. They cannot be, the discretion cannot be oppressive. It cannot be wide. And I hope, and I earnestly hope that very soon Supreme Court will take into account and also deal with this politically exposed person. It's a unnecessary definition which has been brought. It was not required.
The bit on the judges and the military officers, you did say that, it looks like some kind of a psychological pressure on these category of people. Do you also see this as a move where probably, and again, this is something speculative, that probably the government might try and control the judiciary? If you put the judges under this kind of a category, is it also a move where they want to control the judiciary, where they want to control the military officers?
In India, since its independence, regardless of which political party was in power, has dealt with executive trying to control the independence of judiciary. It's happened. We have witnessed that. So let's not single out any party. Every party that came to power attempted that. We've seen the recent controversy about how a person has to be elevated as a judge of a high court or a Supreme Court, the tussle which gets underway, all these things. So our history has witnessed that. Whether the present one is an attempt or it could be done, again, it's speculative, but it doesn't look good on the statute book for a judge who is exercising his judicial function in terms of Article 21 and the constitutional scheme, to see that his name appears as a politically exposed person. It does not look on a statute book of an evolving or an evolved democracy or an evolved constitutional scheme. That is my point.
But would you also admit to the fact that this PEP category now, and when it increases the vulnerability of the judges, it increases the vulnerability of the military officers. Now, supposing if they don't toe the government line, what happens? The ED officer who has unbridled powers, who has unchecked powers, who has been accorded so much of arbitrariness from the government, he could come down heavily if he's got a political dictation.
Again, it's speculative. I mean, I can't say it can happen, but if it happens, I hope the courts will come to the rescue of that particular person. As I said, it doesn't look good. It doesn't feel good. Why should army and judicial officers be included in politically exposed persons category at all? I mean, they are doing their bit. If you find either of them, I'm not saying don't. If you find either of them breaching the law, well, there is a mechanism of sanction and going after them, prosecuting them.
But it does, Manu, leave a lot of scope for misuse, right?
It does. I mean, every law which is oppressive, which is unreasonable, is bound to PEP. I mean, this country has witnessed that. Its laws have been abused, laws have been scrapped. That's the problem. I mean, but we don't learn from our mistakes.
Right. But doesn't it raise a specter of doubt also? And I'm going to throw a little data of what I just researched this morning. Now, 121 leaders have been booked by the ED since 2014. That's the data. And out of that, 114 were from the opposition. And on the basis of this particular data, that's what I'm trying to ask you, that, the timing at which these amendments have been brought about, does it not raise questions? Does it not bring doubts in the minds about the intentions of the government again?
As I said, I mean, yeah, I think your data is self-speaking. It doesn't need my input to say one way or the other. It can be interpreted by a common man. Yes, it does appear that, but how and when and how it's going to be abused, or it's going to be, I mean, that remains to be seen. But I'm sure before it's abused, the courts take cognizance and come down heavily, strike it out, this politically exposed person definition at all, completely. That's my hope.
Manu, as a person, as a journalist who keeps doing political programs almost every day, I'm doing so many shows, and I was just trying to join in a few dots since yesterday, since I came to know, and you were with me on several other platforms yesterday. But what I want to ask you is that when you join the dots, the way these amendments have been brought about just a year ahead of the general elections, look at the number of leaders who are behind the bars, who are being raided. Again, Tejasvi is being hounded. Lalu Yadav in a decades-old case, again, he's hounded by the CBI or the ED. Kavita Rao in the liquor scam. Manish Sisodia is already behind the bars, and the enforcement agencies are hounding him. So the whole point is that if you look at the dots and the way Justice Khanvilkar gave the order, then Justice Ramana came down heavily on it. Then you have another case where the ED director, Sanjay Singh's case is still pending, where they extended his tenure. And that also is a case which is pending. So why is the government could have refrained from, bringing in these amendments till these sticky issues were resolved? Couldn't the government have refrained from bringing in these amendments? Because again, you are giving more powers to the ED.
Yes, I mean, I agree with you entirely. They could have, I mean, not just to refrain from bringing it now, completely refrained. Law is sufficient. It's anyway an oppressive law. I mean, it didn't require this definition at all. Timing, yeah, all of us can make our own interpretation of what the timing is, whether it's an election year or pre-election year, and how cases of parties or political positions sitting on the opposition they are being. So I think we're all intelligent enough to make our own interpretation. But my stand remains the same. It was not required at all. It was unnecessary.
Right, but it does leave that vacuum where this particular amendment now could be used as a political weapon, and the government could use it.
It could use it even before, and any government for that matter. An oppressive law can be used by any government. I mean, why single out the central? I mean, if say in Kerala or in West Bengal, the police wants to register a case which has a scheduled offense, the ED can register a case against there also. So I mean, any oppressive law can be abused, dehouse the political leaning of the ruling party. So I mean, I have personally a problem with laws which are oppressive, which defy constitutional scheme, which militate against Article 21. Who abuses them? I never painted black, white, red. Which party does it? Any party is capable of doing that, and any officer is capable of doing that. But yeah, you can't single out anyone.
Right, but these amendments which have been brought about, they can be challenged in the court also.
Yes. The courts, they can be challenged. Number one, the courts can suo moto also take cognizance of these kind of amendments and ask the government to respond that where was a need to have this kind of a definition in the first place. We are all covered. Every walking citizen in this country is covered by PMLA. Why call 4 of them politically exposed and leave the rest as unexposed? That's the fundamental point here.
I don't know if it is appropriate to ask, but can a judge, when he's taking suo moto cognizance of these particular amendments, can a judge raise an issue as to why a judge, the point which you raised initially, that they are already following a protocol, and so can a judge raise this issue, that how can you bring the judges under this ambit? Can they?
Yes, certainly. Why not? And I hope it happens.
Okay.
This definition is unnecessary. It baffles me. Why was it brought? But an intelligent journalist like you can go into the background and figure out why, instead of posing those questions to a lawyer.
That's exactly why I was joining the dots, Manu. But my last question before I wind up the interview, because there are a lot of allegations against the current government that it is authoritarian, it is fascist, all kinds of names have been given to the Narendra Modi government. But talking about the constitutional architecture, the legal architecture, when you bring in amendments like these, would you really say that your democracy is thriving, or constitutionally you are thriving in the country if you have amendments like these?
So, the very fact that today a judge can question the government, it means that the democracy is thriving. The very fact that you are posing difficult questions, I think the democracy is thriving. The very fact that a common man can read the law and make his own interpretation about it means, and they all go and cast their vote based on their own understanding, democracy is thriving. So, I won't, as I said, I don't want to get into the politics of it all, but I don't see that. I think we are still a thriving democracy. We still are a nation with an independent and very robust judiciary. And I hope it will be taken note of, this new definition, and something will be done about it.
But you do see this as tightening of the scrutiny.
It was already tight. It was
Okay.
already tight. Okay, we're all. I mean, it was not required. That's my personal feeling is. I may be completely wrong. Maybe a better lawyer can give you a better answer, but that's my feeling.
No, you answered most of the difficult questions, and we'll leave it to the viewers to decide as to what they feel about the intentions of the whole government. As you said that, these amendments were redundant, they were not required. Constitutionally speaking, also, it looks arbitrary, all that you have said. So we'll leave it to the viewers to send us feedback as to what they feel is the intention of the government when they bring in amendments like these. It was wonderful having you on the program, Manu Sharma. It was a pleasure talking to you. And one appeal to the viewers who are watching this interview, subscribe to our channel, share this video as widely as you can. Thanks.
Subscribe to the Federal's YouTube page for more news and updates.